Welcome back to Good Law, Bad Law. My guest on today's episode is Ian Millhiser. He is the Supreme Court correspondent for Vox and the author of a new book, The Agenda: How a Republican Supreme Court is Reshaping America. This little tract, I say little only because it is very brief, but so clearly written. Any non-lawyer would get a real education and I think know the important things that need to be understood about where we are in this country. We talk a lot about Congress, we talk a lot about the presidency, but we don't, I think, understand and appreciate as much the power that the Supreme Court wields, how we got into that situation in the first place over the last two generations, and how a new 6-3 conservative majority on the Supreme Court, something we haven't had for a long time. We've had a 5-4 split on the court in terms of the ideology of the justices on the court for some time, but we now, thanks to President Trump and his 11th hour confirmation of Amy Coney Barrett to replace the late Justice Ginsburg, how this new 6-3 majority is going to shape policy, not just decisions on cases, but policy and rights on a range of vital issues, from voting rights to religious liberty to fundamental due process and access to the court. So it is an important and ultimately worrisome conversation, but one I know that you'll all enjoy and learn from. So I encourage you and welcome you to this next episode of Good Law, Bad Law. Stay tuned. I want to welcome Ian Millhiser. He is my guest today on the podcast. He's also the author of the brand new book, The Agenda: How a Republican Supreme Court is Reshaping America. Ian, thank you so much for being on the podcast today.
It's good to be here. Thanks so much.
So you're a senior correspondent at Vox and focus on the Supreme Court. How long have you been doing that?
I've only been at Vox for about 2 years, but I've been reporting on the Supreme Court in one capacity or another for almost a decade now.
Fantastic. Well, I think I was just mentioning to you before we started, I worked as a journalist in Washington many years ago, back in the Reagan Ed Meese days. And
oh man,
one of the big stories I covered was the nomination battle over Robert Bork and the Supreme Court. So my interest in this topic goes pretty far back too. And what a absolutely vitally important subject you've taken on in this book. Very readable, short, and filled with all the background you need to know to understand why this issue is as crucial as it is, and really where we are on the cusp of what could be and likely will be, right, a major swing rightward in terms of the Supreme Court. I think I just loaded the question right there, but what was the impetus for you in writing this book, and why now?
Yeah, I mean, I guess the impetus for it is that after seeing the court move further and further to the right for many years, it then lurched hard to the right under Trump. I think one of the fundamental problems with our democracy is that because the Supreme Court wields so much power, and because the time when the justices leave the court is sort of semi-random, it means that some presidents get elected for a 4-year term and they get to govern for 4 years if they're lucky. Mm-hmm. And other presidents get elected to a 4-year term and their policies can continue for 20 or 30 years because of the impact that they had on the Supreme Court. And Trump is one of those presidents. I mean, he lost the popular vote in 2016. At no point in the Trump presidency, even though Republicans controlled the Senate, for all of the Trump presidency? Did the block of Republican senators represent more of the country than the block of Democratic senators? The Senate's malapportioned. California gets 2 seats. Wyoming gets 2 seats, even though California has 68 times as many people as Wyoming.
Right.
And so there have only been 3 justices in American history who were nominated by a president who lost the popular vote and confirmed by a block of senators that represent less than half the country. And all 3 of them were appointed by Donald Trump.
Mm.
So we have this accidental president who appoints a third of the Supreme Court. Because of Senate malapportionment, 3 justices that he appoints really have no democratic legitimacy at all. And yet it's likely that the policies of this accidental president are going to continue for many, many years because because Trump just happened to get to fill 3 significant seats.
And add to that, Ian, the fact that the Supreme Court of our 3 branches of government is the least democratic institution, because these are appointed justices, and they're appointed for life. They're not elected, of course. And that's with intention, the way the framers designed these 3 branches. But nonetheless, for that branch of our government to have swung to the right in the way it did, in the way you've described, and this is really where I think your work is so important to understand, where the Supreme Court is now poised to carry on what it has been doing for the last 20 years, which is exercising a tremendous power in the shaping of policy, not just deciding cases, but really shaping important policy that affects every American. I mean, that's a pretty profound change.
Right. Yeah. So the theory behind why justices serve for life, why they aren't elected, is that we want the judiciary to be independent. We want, the elected branches, their legitimacy flows from the will of the people. And so we trust them to wield power because they're supposed to exercise, act as proxies for the people who elected them. And if you don't like what elected officials are doing, you can vote them out of office. So they won't hold power for very long, at least in theory, if they're doing the wrong thing. The reason why we give so much power to the Supreme Court or to the judiciary is that the theory is that they are beholden to a written text, whether that's the text of the Constitution or the text of a particular statute, and they are supposed to follow that written text. And so in theory, they don't wield the kind of discretionary power that elected officials do, because a judge is supposed to, just obey the words in a written text. Now, there's 2 problems with that. I mean, one is that written texts can be ambiguous. They can be open to many meanings. And the Constitution in particular is especially ambiguous. If you read the Constitution, it says, for example, that police can't make unreasonable searches and seizures. It doesn't tell you what the word unreasonable means. It uses words like general welfare and due process and cruel and unusual and liberty that are open to, sometimes millions of different meanings. And so smart judges can often take these really vague phrases and read whatever they want into them. And then the other problem is that, and I get into this a bit in the book, even when the law is clear, this Supreme Court doesn't always follow it. I have an entire chapter here about a practice called forced arbitration. Mm-hmm. And so forced arbitration it occurs both in the employment context and in the consumer context. But your boss has the power to send you an email that says you must agree to never sue me and to never sue the company. If you do have a dispute, you have to go to a privatized arbitration system where we, the company, are probably going to pick the arbitrator. And all the data on arbitration shows that individual plaintiffs are much less likely to win in private arbitration. And when they do win, they win a lot less. They're awarded a lot less money. And if you look at what the actual, the basis for this is a statute called the Federal Arbitration Act. And the Federal Arbitration Act says that it shall not apply to workers in interstate commerce, which is basically all workers, if you know anything about like how the court, what the words interstate commerce mean.
Everything is interstate
Right.
commerce today. Yeah.
Yeah. And so it's supposed to exempt workers.
Mhm.
And yet the Supreme Court has held that when the statute says that it doesn't apply to workers in interstate commerce, that actually means that it applies to most workers in interstate commerce. And like, that's just not how the law is supposed to work. And it's disturbing because, like, you know, in theory, if the courts get something wrong, Congress should be able to pass a new law and fix it. But if the courts won't even follow the laws we have written down right away, what are we even doing here? Like, we're no longer a democracy or anything resembling a democracy if the courts won't follow the clear words of a statute.
Well, and that underlies a lot of the way you analyze where we find ourselves today, which, and we've talked about this a lot on this podcast, many people have, that Congress, at the same time as the Supreme Court has found itself making sweeping changes in policy that affect rights of workers, that affect rights of citizens in voting, that affect rights of workers to be not discriminated against in their workplaces, and all kinds of things, Congress has at the same time abdicated its responsibility in making laws. I mean, there's very little that Congress has done. You make the point that in the Trump era, there's really only one piece of legislation you can point to that Congress did, was to give, you know, a bonanza tax break to corporations and the wealthy. That's it, essentially. And that in other times in our history where the Supreme Court veered one way or the other in a decision that it would make, Congress could come along, and often did come along, and fix the problem or fix the situation by passing new legislation, which Congress doesn't seem to do anymore.
Right. Yeah. I mean, I started writing this book really at the end of a kind of lost decade for Congress. So, you know, from 2011, which is when Republicans took the House and denied Obama a governing majority, until 2020, when the pandemic came along and it became completely untenable for Congress to do nothing. Right. Congress did virtually nothing at all. I mean, they passed Trump's tax bill, but like besides that, you know, we'd have a fight every now and then over whether we were going to fund the government or like whether or not we were going to default on our debts, you know, but like Congress was barely able to do the sort of basic maintenance that it has to do just to keep the country operating for 10 years. And in that same period, the Supreme Court dismantled our campaign finance law. It hobbled the Voting Rights Act. It weakened the ban on sexual harassment. It said that plaintiffs making religious liberty claims can trump the rights of other people, including their own employees. It halted President Obama's Clean Power Plan, which was his most ambitious effort to fight climate change. It weakened unions. And then, you know, lest you think that it was nothing but bad news, there was also the marriage equality decision. Mm-hmm. So in this period when the legislative branch was basically doing nothing, the Supreme Court was extremely busy. You know, it made a number, I mean, that's just a short list. You know, there's others I could add. Right. It made a number of extraordinarily significant changes to U.S. policy. The Supreme Court became the locus of policymaking in the United States. And I mean, that bothers me because I don't agree with the court's politics, but it also bothers me because look, I voted for Joe Biden. Like, you know, I voted for people expecting them to be able to govern. And you know, if my guy loses an election, that's fair. Like, you know, if we have a free and fair election in 2024 and Biden loses fairly, then like whoever runs against Biden should get to govern. That's how democracy works. Right. But what shouldn't happen is that Congress shouldn't essentially lay dormant while, and the presidency shouldn't, become increasingly more and more dormant because the Supreme Court's stripping away a lot of its authority, while the one unelected branch of government gets to decide what our policy is going to be.
Well, and I want to get to your analysis and sort of forecasting on certain major issues that face our country and what you think the Supreme Court is likely to do, not only with a new 6-3 conservative majority on the court, but with the power that the Supreme Court has become accustomed to exercising as a court. But I want to tease out another thread in the story here, which again I think dates back, and you didn't personalize it to me, but you do trace this in the book. The what some have called the conservative judicial campaign. I mean, which started during President Reagan's time, when they started really imposing litmus tests on who they were going to nominate to all the federal courts, but especially to the Supreme Court, and culminates with Trump's late hour, last minute ramming through, I would say, of Amy Coney Barrett's confirmation following the death of Ruth Bader Ginsburg. But it seems to me it's more than just counting up votes on the Supreme Court. It's more than just, okay, it was 5-4 for a really long time on so many important issues, such that we would talk about there being a swing vote. It was Justice Kennedy for a while, for a brief time. As you point out, it was our Chief Justice Roberts. Now it's 6-3, but it's a lot more than just the counting up of who's who on the court, isn't it? It really is a reasserting of a power from the Supreme Court by these conservative justices, which is so ironic, because where this all started was with Ronald Reagan saying he was going to choose justices who would exercise judicial restraint.
Right.
And now we have the completion of this conservative judicial revolution, where it's anything but restraint, if it ever was.
Right.
But now it is judicial activism. It's just conservative judicial activism.
Yeah. So I trace this history back to Franklin Roosevelt. So before President Roosevelt was elected, we had just an awful Supreme Court, and they would implement conservative policy for the thinnest reasons. This is when the court struck down child labor laws. It's when it struck down minimum wage laws. And when Roosevelt came into power, the court started striking down a lot of New Deal policies. Mm-hmm. And there's two ways that Roosevelt could have handled that. One way is he could have said, look, the Supreme Court's really powerful. I want to get these New Deal policies implemented. So I'm going to appoint a bunch of justices who will implement my policies from the bench. He could have done that.
And he tried that at one point.
Well, here's the thing. He didn't try that. I mean, he did do a lot of things to try to weaken the court's power. But that's the point, is that his goal was to weaken the court's authority.
Right.
Roosevelt's goal was to get the court out of the way, so that he and the Democratic Congress could govern. And I mean, I think that's how confident political leaders tend to think about the judiciary. Roosevelt won 4 elections by pretty large margins. Like, when you are that confident that you have the American people behind you, you tend to think, look, like, just let me govern. Like, I've got a mandate. I don't want these judges messing around, and I don't want them making my decisions for me. I'm the one who got elected. I have a mandate. Just get out the way and let me do it.
Right.
And if you look at President Reagan's rhetoric, for example, Reagan's rhetoric about the court was very similar to Roosevelt's. And that doesn't surprise me, because, like, whatever you think about Ronald Reagan, he also won 2 elections in landslides. Like, Reagan had every reason to be a confident leader because, at that time, the American people really did want what Reagan was selling. Mm-hmm. And, Reagan had, he had a mandate. And so why would he want the courts deciding things for him
Right.
when he had the will of the people behind him. And now you flash forward to the present. The Republicans have lost the popular vote in 7 of the last 8 presidential election. Like, the only reason they have any chance of governing at all is because the electoral college gives extra votes to like parts of the country that favor Republicans, and because the Senate is malapportioned.
That's right.
And so when you don't have confidence in your own ability, in your own mandate, and that the people are actually behind you, I think once you lick the lollipop of minority rule, you suck it forever. Like, once you, yeah, like once you accept it's legitimate for Donald frickin' Trump to become president after he loses the popular vote by, more than 2 billion, by more than 3, or, by almost 3 million votes. And then to, have this Senate where, you only represent a minority of the country, confirm all these judges, and like enact whatever laws. Like, once you accept the legitimacy of all of that, then like it's not a difficult step to say, well, why don't we just let the branch that isn't elected and that we control do whatever it wants to do? So, I'm not surprised that we've seen this turn. I think that this turn towards anti-democracy, like, the same thing that causes the Georgia state legislature to say, we're going to try to shut down a bunch of precincts in Atlanta. We're going to make it as hard as possible for voters to cast a ballot, is the same instinct that I think causes Republicans in DC to say, well, why don't we just let the Supreme Court be in charge because we control it?
Well, right. You can't win by getting more votes. So you have to prevent the other guys from getting more votes.
Right. And when they do get more
crazy.
votes, you prevent them from governing entirely. Like, I have an entire chapter in here about, I mean, this is going to sound really dull, but it's really important, about what is often referred to as the administrative state. So Congress, if it wants to pass a law, if it wants to regulate, can do it in 2 ways. Like, let's say that Congress wants to prevent power plants from spewing pollution all over the place. One way it can do that is it can just pass a law saying every power plant has to install the following device, which, will help reduce emissions. And like, that'll work for a little while. But the problem is that if Congress had passed that law in 1974, all these power plants would still be using the same technology that existed in 1974, and the law might actually be counterproductive. It might actually prevent them from putting something new in place. So that's not what Congress did. It passed the Clean Air Act. And the Clean Air Act says, first of all, that power plants, or at least certain power plants, have to use the best available technology. That's the language that the statute uses, the best available technology to reduce emissions. And then it says that the EPA's job is to figure out at any given moment what the best available technology is. And when new technology emerges, EPA will issue a new regulation saying, okay, guys, guess what? There's this new thing. You all have to use this right now.
Mm-hmm.
And what's great about that approach is it's still democratic. Like, still Congress determines that the policy is that everyone has to use the best available technology, but it's dynamic. The system maintains itself. The EPA can keep updating the regulations. You don't need to pass a new act of Congress through both the House and the Senate and get it signed by the president every time someone invents a new device that you could use to reduce carbon emissions. It just happens. The system, will be able to work on its own. And this can give presidents a tremendous amount of power because presidents appoint EPA administrators. They appoint people to other agencies who also have authority to oversee these sort of regulatory regimes. And it is true that in Democratic administrations, the EPA tends to be a little more aggressive, and in Republican administrations, it tends to be a little less aggressive. But what the Supreme Court is fixing to do, there's 5 justices who have endorsed this, they just haven't all gotten together and said it in one opinion, is to essentially give itself a veto power over any agency that tries to regulate in this way. So instead of the rule being that Congress decides what the policy is, everyone has to use the best available technology, and then the EPA implements that policy, The rule will now be Congress decides what our policy should be. The EPA tries to implement it, and if the Supreme Court doesn't like it, it vetoes it. And like, that's not democratic, but more than that, it potentially makes Biden one of the weakest presidents in modern history, because every other president has been able to exercise authority under the Clean Air Act. Every other president has been able to exercise the authority that Congress has given it to regulate in various different ways. But the Supreme Court's now going to decide that, oh, well, if we don't like what the Biden administration is doing,
Yeah.
we'll just veto it.
Right. And it's this very arcane and technical legal idea as to why these administrative agencies, you give the example of the EPA, but people are very familiar with others too, the FDA, the FTC, in terms of things like advertising of products in business, the FEC in terms of election regulations. I mean, these are agencies that affect so many aspects of all of our lives. And we talk about the big lie that Trump put forward, that the 2020 election was rigged and it was a fraud and all, but this idea that we are, as a country, buckling under the weight of so much regulation. I understand why big business, wants to get rid of as much regulation as they can and return to an era when so-called free market practices, governed. But why are voters who depend on clean air for their children, who depend on, all these protections that the free market isn't on its own providing, would buy into this idea as well, is pretty stunning. And as you point out, it's not Democrats that are putting this forward. Republican and Democratic presidents, Republican and Democratic Congresses have supported, benefited from, voted for all kinds of agency regulations over decades now.
Right. Yeah.
But that could all go away in one single case. If the right case comes up to this court, you're saying there are enough votes on this court that an entire way of governing that's been in place for decades could disappear.
Yeah, and I'll say two other things. But I mean, one is like, one reason why I think the Supreme Court is able to get away with this, and one reason why like the Republican Party is able to get away with implementing so much of its agenda through litigation, is because this stuff is really complicated and like often it's just hard to understand. I mean, I have been in the business of explaining complex legal developments to the public for the last decade. I like to think I'm pretty good at it.
Mhm.
And like, look at how long it took for me to explain what regulations are and how the Clean Air Act works and like, how agencies operate. Like, I mean, this isn't stuff that I think if you're not a lawyer, most people just intuit about how our government works. And not only is it not something that people just sort of intuit, but it's not like the Supreme Court, when it writes about it writes about it with a great deal of clarity. Like, I could tell you what that opinion is going to say when it gives itself a veto power over everything that federal agencies do. It's going to say like, well, there are constitutional limits on Congress's ability to delegate, and so we are going to implement the non-delegation doctrine. And now I'm going to ramble for 20 pages about how Article 1 of the Constitution refers to the legislative power and Article 2 refers to the executive power. And here is my theory on what the limits on the executive power is. And now I'm going to articulate this extremely vague standard that courts have to apply. And I mean, I'm a lawyer. I went to law school for 3 years, and then I've spent, the next 12 years, like, learning how to understand what courts are actually saying when they spend 20 pages going on about, well, the legislative power means this and the executive power means this. But like, it's not reasonable to expect ordinary voters to understand what all that stuff means. And so the Republican Party is able to get away with a lot of stuff because it's implementing really radical policies and really unpopular policies in ways that people don't see and don't understand.
Right. Well, let's take one then that I think ought to be very easy to understand, and it's the first major set of issues that you take up in the book after setting up the problem and setting the scene, and that's voting rights.
Yeah.
We've already seen this court, before it was a 6-3 conservative majority, strike down major parts of one of the great achievements of the Civil Rights era, the Voting Rights Act. But you argued that this court, now with the 6-3 majority for the conservatives, is poised to do even more to turn back the clock and turn back people's rights in terms of voting. This seems like one that ought to be so easy for all of us to understand. Why would the Supreme Court, in defense of one of the most fundamental rights or confronting cases involving arguably the most fundamental right we have as American citizens, the right to freely exercise our vote and not be inhibited unduly and not be intimidated unlawfully in exercising our vote, how is it that this court can be poised to endorse, for example, what's happened recently in Georgia and more recently in Florida, that is states enacting laws that all so baldly on their face are designed to limit people's access to the polls?
Yeah, I mean, I wish I knew why this court was so hostile to voting rights. I mean, I know that they are hostile to voting rights. I mean, Chief Justice Roberts is the most moderate member of the court's 6-justice Republican majority. And when he was a young attorney in the Reagan administration, he was the point person trying to prevent President Reagan from signing a bill that, to his credit, Reagan did sign, which reinstated much of the Voting Rights Act that had been dismantled by the Supreme Court in 1980, and that strengthened various parts of it. So this has been a lifelong crusade of Roberts. And again, Roberts is the least conservative member of the Republic. So they really do care about this. I will make a few quick points about voting rights. One is that if you talk about voting rights in this country, you really do have to talk about race. Mm-hmm. And I don't necessarily think that's because, who knows what's going on in the head of these Georgia and Florida lawmakers, but I don't necessarily think it's because they're white supremacists. I don't necessarily think it's because, lawmakers in Florida are sitting around thinking, we think Jim Crow was good. And we think that the way that society should be structured is white people should rule and black people should have no say in, I don't necessarily think they think that. But here's what is true. So Democrats typically win, if you look at the polls in any recent election, they typically win between 80 to 90% of black voters and between 60 to 70% of Latino voters. And so if you are, say, a Georgia state lawmaker, and your goal is to prevent Democrats from winning elections, you can use race as a proxy to identify where a lot of Democrats live. So there's a provision in this terrible Georgia law, for example, that allows the Republican-controlled state legislature to effectively take over local election boards. And once they take over local election boards, they can disenfranchise individual voters, they can shut down precincts, they can potentially refuse to certify election results, they can do a lot of scary things. And so the danger is, they can go to a black neighborhood in Atlanta and they can shut down most of the precincts in that neighborhood. And if they do that, they can be fairly confident that the people who aren't going to get to vote because all those precincts were shut down are Democrats. And that is why the Voting Rights Act, which primarily deals with racial voter discrimination, is so important. It's because even if you don't have lawmakers who in George Wallace factions are rubbing their evil hands together and saying, ha ha ha, I'm going to make sure that only white people get to rule. Right. You still have these racist laws being enacted, and they're being enacted because race can be used as a proxy to identify where a lot of Democrats live. And the Supreme Court has largely blessed this. I mean, we can go into more detail about this, but the Supreme Court has been dismantling the Voting Rights Act since 2013. There's a case in front of the Supreme Court this term, it's probably going to be decided next month, that could potentially dismantle what remains of the Voting Rights Act.
What? So, but I still don't really, and I'm not sure if this gets to the ultimate why or if this helps get to the ultimate why on voting rights. You can talk about conservative judicial philosophy. Again, in the Reagan years in the 1980s, it was judicial restraint. The way Justice Scalia talked about it, it was originalism, it was look at the text. Now you can look at those and say that's a bunch of baloney. It's really ultimately just about what you want to see happen, and that's just your vehicle for getting to where you want to get to. But at least you could have an honest debate, it's mostly honest debate, about the role of each of the branches of government, about the role of the Constitution. Do you just look at the text, or is it a living? You could have those discussions as a way of approaching a particular issue and how you would decide a particular issue. Even the Second Amendment. I mean, I think a lot of the right-wing judicial rationalization of expansive individual gun rights by looking at the text of the Second Amendment is a bunch of bullshit. But okay, you can still look at those debates and see mostly valid, certainly defensible legal and constitutional arguments. I'm really still missing it, though, in terms of voting rights, because if what you're saying is that not only are members of the Georgia state legislature, not only are members of the conservative bloc in Congress in Washington looking at pure craven minority politics and how to preserve power, but the Supreme Court is doing that. I mean, that's pretty disturbing, and I don't even know how it's defended as a matter of constitutional, legal, or judicial philosophy.
Yeah, no, I mean, a lot of these voting rights decisions are really not just shocking, but like, I don't, as a lawyer, understand where they come from. So let's take a particular decision, Shelby County v. Holder. So Section 5 of the Voting Rights Act says that certain states with the history of racist voting practices have to, the word in the statute is pre-clear. They have to have an official in Washington, D.C. look at any new voting rule that they put in place to make sure that it's not discriminating on the basis of race. And if it doesn't have any racial problems, it goes into effect. And if it does, then it's stopped before it goes into effect. So the idea is to halt these laws before they have the chance to disenfranchise anyone. Hugely effective. I mean, arguably the most effective civil rights statute in American history. I think like Mississippi, before pre-clearance went into effect, something like I think 7% of African Americans in Mississippi were registered to vote. After pre-clearance went into effect, 60%. So like this is a big deal. Like this really worked. And I can read to you, because it's only 2 sentences, what the Constitution says about this. So I'm going to read the text of the 15th Amendment now. First sentence is, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. So that's just stating the principle that, like, we're not supposed to have racist voting laws. And then the second sentence is very important. The second sentence is, the Congress shall have the power to enforce this article by appropriate legislation. And the reason I point to that second sentence is because it's telling you who has the power to decide how we're going to get rid of racist voting laws. It says, first of all, everyone should be able to vote on regardless of race. And second of all, Congress has the power to make sure that actually happens. So who has the power to decide what, like Section 5 preclearance is not required by the Constitution, but the Constitution says that Congress gets to decide whether we have it or not. Congress gets to decide how we stop racism from infecting our elections. And the Supreme Court in Shelby County really didn't engage with the text of the 15th Amendment at all.
Mm.
What it said instead is Roberts wrote the opinion, and he invented this doctrine that he called the equal dignity of the states. The idea was that it is somehow unfair, because again, the way that preclearance works is that only states that were deemed to have a history of racist practices were subject to preclearance. And so it was unfair to treat Mississippi differently than you treat, I don't know, Maine. It's unfair to treat Alabama differently than you would treat, I don't know, Oregon. Like that was his argument. And like, I don't know if that's unfair or not, but I do know that the Constitution says nothing about whether you can have a law that applies only to Mississippi or and not to Oregon. What the Constitution says is what the 15th Amendment says, that Congress gets to decide whether or not we're going to have special rules that prevent states that have a particularly nasty history from from engaging in racist practices. Again, it's not up to the Supreme Court, it's up to Congress.
Right. So what should happen, and as you trace in the book, what has happened at other points in history is when the Supreme Court issues a decision like it did in Shelby County, striking Section 5 of the Voting Rights Act, eliminating that burden on the former Jim Crow states of the South, Congress should step forward and say, wait a second, you didn't have the right to do that because the Constitution in the 15th Amendment says Congress shall have this power, and we're going to assert that power, and we're going to fix that problem. But that doesn't happen for other political reasons. I mean, there were, one of the next big legislative initiatives is a repair of that. I think it's HR and SR1. It's the first bill.
It's HR 4 actually that has the voting rights.
Oh, it's HR 4. Okay.
Yeah.
It's one of the first bills.
Right.
Both new Congress after new Congress after new Congresses to fix this. And, the McConnell wing, the McConnellites, the Republicans, and he even came out recently making, again, no secret of this. He's going to do everything in his power to shut down the Biden legislative agenda, not with an alternative agenda, just shut down the Democrats. So Congress isn't going to probably have the ability, because of our politics, to step forward. And that just creates more of this vacuum for this new conservative majority in the Supreme Court to do what it will do, unchecked, right? And so what more can they do, I guess, is the question. I mean, they've already so weakened the Voting Rights Act. What is the more that you see coming along, in the next couple of terms?
Well, here's what my overarching fear is that, so we have a system that's so profoundly broken. So like right now we have a Democratic president, we have a Democratic House, we have a Democratic Senate. Not only do we have a Democratic Senate, but even though it's a 50-50 Senate, the 50 Democratic senators represent about 41 million more people than the 50 Republican senators. So like if we chose our senators in free and fair elections where everyone counted equally, Democrats would have maybe 54 seats in the US Senate. It's only because of malapportionment that like they have such a narrow majority. The House keeps passing voting rights bills. And in the Senate, we probably would be able to pass them if it wasn't for the filibuster.
Yep.
But we can't get rid of the filibuster because Manchin and Sinema want to keep the filibuster. If we had a 54-seat Democratic majority, Manchin and Sinema's views on the filibusters wouldn't matter. Right. But in a 50-senator Democratic majority, like Manchin and Sinema can you have to get every single Democrat on board just to break the filibuster, and then you have to pass the damn bill after you break the filibuster. And like, look at how we got to the point where we could have just a 50 senator Democratic majority. You had an accidental president who was a complete and utter disaster, like had barely any response to a pandemic. Democrats ran like the candidate who would, most appease the sorts of voters who were inclined to Trumpian backlash, an old moderate white guy.
Mhm.
And like, even under those circumstances, and then like, you had 2 seats in Georgia that came down to runoffs. And realistically, the only reason why Democrats won those seats is because Donald Trump threw a temper tantrum
Right.
and like spent the period before the runoff complaining that like the Georgia governor wouldn't overturn the results of Georgia's presidential election. So like he split Republicans and like they weren't as inclined to turn
Well,
out.
and because more people voted too. I mean, there was for a period of time an expansion of access to voting in
Right.
Georgia. And this is what happens.
Yeah.
Republicans lose when that happens.
Yeah. So you had a perfect storm.
Yeah.
And when you had a perfect storm where every tumbler lined up to help Democrats, you were still only able to get a 50-50 Senate, even though, again, the 50 Democrats represent 41 million more people. And as it turns out, 50 senators ain't enough to pass voting rights bills. And so the Supreme Court can keep marching on, and they have done more to dismantle the Voting Rights Act. There's a case called Abbott v. Perez. So there's 3 prongs to the Voting Rights Act. One is preclearance that I talked about before. The second is called the intent test, which just says that if you enact a voting law with racist intent, it'll be struck down. Abbott, which was decided in 2018, set the burden of proof to prove racist intent so high that it's almost unsurmountable. Like, I mean, like, if you can show that the lawmakers burned a cross during a live showing of the movie Birth of a Nation while they were voting to pass the bill, then maybe you can convince the Supreme Court that there was racist intent. But Justice Alito will still dissent. But like, maybe you'll be able to convince them under those circumstances that like, but anything short of that, it's almost impossible to prove. And then the third prong of the Voting Rights Act is called the results test. And the results test is super complicated. But it means that some laws that have a disproportionate impact on voters of color will be struck down. And that's what the case that's in front of the court right now is about. It's called Brnovich. And like the parties in Brnovich basically asked the Supreme Court to eliminate the results test. I mean, they don't say explicitly eliminate the results test. They want the court to do the same thing it did in Abbott v. Perez. They want to make it so hard to win a results test case that it's basically impossible. And I mean, I don't know, like I watched that oral argument. I think the Supreme Court might take some incremental steps against the results test without knocking it all down in one fell swoop. But several justices, including Roberts, who's the most moderate member of the Republican bloc, have signaled that they think things like the results test are unconstitutional. That was what Roberts tried to stop President Reagan from signing. It was Reagan who signed the bill that created the results test. And Roberts was several clicks to Reagan's right and tried to stop Reagan from signing this bill. So like, the future we're probably looking at is that you don't have the preclearance and you don't have the intent test and you don't have the results test, which means you don't have the Voting Rights Act. And then we're in the same legal regime that we were in Jim Crow. Then we have the same safeguards against racist voting laws that existed in Mississippi in 1940. And we've seen once how that turns out. So that's my fear is that we have seen this movie before, and I'm afraid that there are 5 or 6 justices on the Supreme Court who watched that movie and now they want a sequel.
Ian, I'm very concerned. I'm not happy right now, but we need to understand this. And so I'm really asking people to take a look at your book, the agenda. The one issue we didn't really get a chance to talk about much, but is another big issue that we've already seen some important decisions coming out of this court, likely to see more in the same vein as there are now 6 conservative members, but Think the Colorado cake shop case as an example of uh, not just focusing on religious liberty, but really elevating individual religious liberty to a place where you can imagine all sorts of other really, really important rights that we've come to take for granted, especially since the civil rights era, could be weakened substantially by this court. You talk about that in the chapter of the book after you talk about voting rights. This is about 100 pages. We will put a link to the book in the description for the episode so people can get it. It's very readable. It's extremely well and clearly written on, I don't know that you could say the most important issue, but certainly a set of issues that affects all of our lives every day and some of our most fundamental rights. And if the voting rights agenda gets through, it could have profound implications for our politics for a long time to come as well. So I'm really recommending Ian Millhiser's book, The Agenda, How a Republican Supreme Court is Reshaping America. We'll put a link to it so people can get it and purchase it easily. And well, thank you, Ian,
Thank you so much
for being on the podcast today. It was great to talk with you.
All right. Thanks again.